Have you ever sat in a room full of people celebrating work you spent 8 months building, while the man who took credit for it called you a burden out loud? That happened to me 11 days ago. At a dinner my father hosted to announce my brother's promotion to named partner. In the private room of a restaurant my father had reserved with client retainer funds he wasn't supposed to touch. With 40 family members watching, he looked across the table and told me I'd never last a week without the protection of his name on my office door. I didn't argue. I didn't cry. I set my keycard on the white tablecloth and walked out. What my father didn't know was that I had spent the previous 4 months building a case against him that a former federal prosecutor would later describe as the most methodical documentation of attorney escrow fraud she had seen in 20 years of practice. 48 hours after I left that dinner, he received a notice from the state bar. 72 hours after that, his firm's operating accounts were frozen. My name is Claire, and this is how I brought down a 20-year empire using the same legal skills my father pretended belonged to my brother. My father's firm occupied 3 floors of a glass building in downtown Atlanta. Hartwell Family Law. The name had always been a small irony to me, given how little the man running it understood family beyond its usefulness as a brand. 40 attorneys, a paralegal team, 2 receptionists who had worked there longer than most of the lawyers. Every morning I arrived at 7:15, parked in the garage with my own monthly payment, and walked past the framed feature from Atlanta Business Chronicle on the wall near the elevator. My father's photo. His quote about building a legacy. The article mentioned his son by name in the 3rd paragraph. I was described as additional staff. I had passed the Georgia bar on my first attempt. Finished in the top 8% of my class at Emory. My father had attended my graduation and spent most of the reception talking to the dean about my brother's upcoming enrollment. My brother had failed the bar twice before passing on his 3rd attempt, a detail that my father referred to as character building in every retelling. For 8 years I was the firm's senior associate in everything but title. I managed the high-asset divorce cases, the ones where the money was large enough to require someone who understood forensic accounting and asset concealment. I built the firm's reputation in that niche almost entirely from scratch, starting with a $4 million settlement I negotiated 2 months after I was hired. My father announced that settlement at the quarterly staff meeting and pointed to my brother, who had been assigned to shadow me on the case, as evidence of the next generation's promise. My brother's actual contribution to that case had been forwarding me 3 emails and attending a deposition where he asked one question I had written on an index card for him. The pattern was not subtle. I would spend 4 months on a complex case, draft every brief, prepare every witness, sit through every mediation. My brother would appear for the closing arguments wearing a suit our father had paid for, and the client would leave thanking him. I would return to my office and begin the next case. The junior attorneys on my team knew. They said nothing, because my father signed their paychecks. One of them, a second-year associate named Jessica, left a sticky note on my computer once that said simply, "We see you." I kept it in my desk drawer for 3 years. The moment that changed everything was not dramatic at first. It appeared as a $6,000 discrepancy in a client's escrow account during a routine file review I was conducting on a Monday morning. The client was a woman going through a high-conflict divorce with substantial marital assets. Her retainer funds were held in the firm's IOTL account, a trust account governed by strict bar rules. Money in that account is not the firm's money. It is the client's money, held in trust until it is earned. The $6,000 was not there. I looked again. I checked the disbursement records. I pulled the receipts. There was no documentation for that withdrawal, no matching invoice, no court filing that would have triggered a legitimate disbursement. I closed the file and sat very still for a long moment. Then I went back through 6 months of records. What I found made the $6,000 look like an accounting rounding error. Over 18 months, my father had withdrawn $340,000 from client trust accounts across 11 separate cases. The withdrawals were irregular in size, always just below the threshold that would trigger automatic bank reporting. Each one was coded with a file number that corresponded to legitimate cases, but when I cross-referenced the actual case expenses, The numbers did not match. The money had moved from the aisle to account to the firm's operating account, and from there to a separate account I did not recognize. I ran that account number. It belonged to a limited liability company registered in Delaware. The registered agent was a name I did not know, but the signature on the operating agreement, which I found attached to a formation document that had been misfiled in a client folder, was my brother's. I did not go to my father. I did not go to my brother. I went to the copy room, made 3 sets of everything, sealed 1 set in an envelope addressed to my personal attorney, drove to a UPS store during my lunch break, and mailed it. I spent the next 4 months continuing to work as if nothing had happened. I took new cases. I billed my hours. I attended the firm's quarterly dinners. I watched my brother receive client praise for work I had done. I documented everything. I want to be precise about why I waited. I am a licensed attorney. If I had disclosed client confidential information without completing a proper withdrawal from representation, I would have risked my own license and potentially tainted any subsequent bar investigation. The rules governing attorney conduct are not suggestions. I could not act from inside the firm without becoming liable myself. So I prepared everything I needed to act from the outside, and I waited for the moment my father would give me the reason to leave. He provided it on a Tuesday evening in October. The dinner was at Bacchanalia, a restaurant my father frequented for client entertaining. He had reserved the private room for what the invitation, sent through his assistant, described as a family celebration. When I arrived, 40 members of our extended family were already seated. My mother at the end of the table nearest the door, my aunts and their husbands, cousins, I saw twice a year, my father at the head, my brother beside him. My father stood when the appetizers were cleared. He gave a toast about legacy, about what it means to build something lasting, about the responsibility of passing a name to the next generation. He announced that my brother would be named partner, effective January 1st. He described my brother's vision for the firm's future. He mentioned a case my brother had recently closed, which I had worked on for 7 months, as evidence of the leadership qualities that made him ready. 40 glasses rose. Mine stayed on the table. My father continued. He said something about how success required difficult decisions about who was truly adding value and who was simply benefiting from proximity to it. He was looking at me. He said the firm needed people who could originate business, who could work a room, who could close. He said that supporting roles, however necessary, were not the same as leadership. I understand this is a difficult concept for some people to accept, he said. His eyes did not move from my face. My cousin across the table shifted in her seat. My mother looked at the tablecloth. My father raised his glass again. I want to offer a challenge, he said, the way someone says it when they do not expect to be taken up on it. If you believe you've built something of your own in this firm, let's find out. Try surviving 1 week without the Hartwell name, without the clients I brought in, without the cases I assigned you, without the office I gave you. See what you're actually worth. The table went quiet. Someone's water glass clinked against a fork. I reached into my bag. I took out my building keycard and my client access fob, the 2 items I had brought specifically for this moment, having suspected for the past 2 weeks that this dinner was not actually about my brother's promotion. I placed them on the tablecloth between my bread plate and my water glass. You're right, I said. I should find out. I stood, said goodnight to my mother, and walked to the exit. I heard my brother say something. I did not hear my father say anything at all. The Hampton Inn, 3 miles from the restaurant, was clean and anonymous. I paid cash for 4 nights from a personal savings account I had opened 6 years earlier at a bank my father had never heard of. I had $22,000 in that account, accumulated from speaking honorariums, a consulting fee from a firm that had brought me in on a complex case, and 8 years of birthday checks I had deposited without mentioning to anyone. My phone began ringing before I reached my room. My mother twice. My brother 4 times. My father sent 1 email at 10:47 p.m. Come to the office at 8 tomorrow, and we will discuss this like adults. Your behavior tonight was an embarrassment. I did not respond. I opened my laptop, the personal one. not the firm-issued machine I had left in my office, and I began organizing files. At midnight, I called the attorney I had retained 6 weeks earlier, a woman named Patricia Owens, who had spent 15 years as a state bar prosecutor before entering private practice. She answered on the second ring. "I'd been expecting this call," she said. I told her I had left the firm. "Good," she said. "That removes the last procedural barrier. I can file the bar complaint Monday morning. Can you be at my office at 7 a.m.? I said yes. "Bring everything." My brother's calls increased to 11 by morning. My mother's messages shifted from sharp disappointment to something that sounded like fear. She left a voicemail at 6:15 a.m. that said, "Your father hasn't slept. The Devereaux clients are calling the office. I don't know what you've done, but please, just call him back." I didn't know what the Devereaux clients were calling about yet. I found out later. Patricia's paralegal had made a call Sunday afternoon to the Devereaux estate executor as a courtesy notification that a bar investigation was likely to involve their case file. The executor had immediately contacted his personal attorney. His personal attorney had called the firm. The firm had no idea why. Patricia's office was on the 14th floor of a building 2 miles from my father's. The conference room had a long window that looked east toward the skyline. She had 6 attorneys on her staff and a forensic accounting consultant, a woman named Dr. Randall who had flown in from Charlotte. Patricia set a yellow legal pad on the table and folded her hands. "Walk me through everything from the beginning," she said. I did. I took 2 hours. Patricia did not interrupt. Dr. Randall took notes in a precise, small handwriting. When I finished, Patricia looked at her consultant, and the consultant said, "This is extraordinarily well documented." Patricia nodded. "The bar complaint goes in this morning. We're also contacting the Georgia Bureau of Investigation's Financial Crimes Unit, because what you have here goes beyond bar violations into criminal misappropriation, and we're reaching out to the affected clients directly." "What about my brother's company?" I asked. "That's the part that concerns me most," Dr. Randall said. "He wasn't just a passive recipient. The LLC he set up received disbursements on 12 separate occasions. That's not an oversight. That's a structure." Patricia looked at me steadily. "You understand this is going to be very public." I thought about 8 years of credit taken. About the sticky note in my desk drawer. About 40 people at a dinner table watching my father challenge me and looking at the tablecloth. "I understand," I said. The bar investigation moved with unusual speed because the documentation was complete. Patricia later told me she had never submitted a complaint with that level of cross-reference supporting material. Every withdrawal was matched to a source document. Every transfer was traced through 3 account levels. The forged co-signatures on 3 disbursement authorizations, documents that bore my brother's signature but had been analyzed by a handwriting specialist Patricia retained, were matched against exemplars from contracts my brother had signed over the past 2 years. The GBI opened a parallel inquiry by Wednesday. I did not know any of this was happening when my phone rang Thursday morning with a number I did not recognize. The caller identified herself as the managing partner of a firm in Buckhead, a woman I had met once at a bar association conference 3 years earlier. "I've been following what's happening with Hartwell," she said. "I want to be clear that I'm calling before any of this becomes public record. I've been watching your work for 2 years. Would you be willing to meet?" I said I would. I also received a call Thursday from someone I had not spoken to in 4 years. My grandmother's attorney. She had been the one who, when my grandmother passed, had handled the distribution of a small estate that included a handwritten letter my grandmother left me alone. The letter was 3 paragraphs. It talked about watching my father build his career. It talked about watching me join his firm and observing, from her position as an elderly woman whom powerful men tended to underestimate, what was actually happening in that office. The last paragraph said, "I'm leaving you a gift that isn't money. I'm leaving you my name on the client referral letter I wrote to every senior attorney I know in Atlanta. They've been waiting to hear from you. I told them you'd call when you were ready." I had read that letter the day she died. I had put it in a fireproof lockbox in my apartment and told no one it existed. Her attorney was calling to tell me that 2 of the attorneys on my grandmother's referral list had reached out to him, having seen my name connected to reports circulating in the legal community. They wanted to know if I was available. I called both of them back the same day. The firm meeting was scheduled for Friday morning. I did not know about it until Patricia received a call Thursday afternoon from the Bar Association's intake investigator, who informed her that Hartwell Family Law's managing board, a group of 3 non-Hartwell senior partners who held minority stakes in the firm, had convened an emergency session and requested the presence of the bar's representative. Patricia looked at me across her conference table. "Do you want to be there?" "Yes," I said. "Then let's go." I wore the suit I had bought with my first bonus check 8 years ago, the one I had purchased before my father told me the firm had a dress code he expected associates to represent at a certain standard, and handed me a credit card linked to a firm account I had never asked for, and immediately returned. The conference room at Hartwell was the one I had spent more cumulative hours in than any room outside my apartment. I knew every scratch on the mahogany table. I knew which chair rolled slightly to the left. I knew the window faced northwest and let in direct afternoon light that made presenting from the east side of the room difficult after 3 p.m. My father was already seated when I walked in. My brother was not present. I would find out later that my brother had not come into the office that morning, and that his assistant had received a text from him at 6 a.m. saying he was ill. My father looked at me the way someone looks when they have been told a thing is happening and still cannot make it feel real. The 3 managing partners were at the table. The bar investigator, a quiet man named Carter who had introduced himself to me in the hallway, was at the end. Patricia sat beside me. Dr. Randall was at the table as well, her laptop open. Patricia did not begin with an apology or a preamble. She opened a folder and placed the first document in the center of the table. "Exhibit 1, she said. IOLTA account statements for Hartwell Family Law covering January of 2 years ago through August of this year. Highlighted in yellow are 23 withdrawals totaling $345,000 that do not correspond to any documented client expense, court cost, or properly authorized disbursement." The room was quiet in the way rooms get when the air changes. "Exhibit 2, Patricia continued. Operating account records showing the transfer of those funds to an account held by Hartwell Advisory Group LLC, a Delaware entity formed 18 months ago. One of the managing partners, a man named Douglas who had been with the firm for 12 years, leaned forward to read the document. His expression did not change, but he was very still. "Exhibit 3. The operating agreement for Hartwell Advisory Group, bearing the signature of the individual listed as managing member." My father turned to look at the document. Something in his face shifted. "Exhibit 4, Patricia said. Handwriting analysis of 3 disbursement co-authorizations signed under the managing member's name, compared against 12 authenticated signature exemplars. The conclusion of our specialist is that the co-authorizations are not genuine. My brother had not signed those documents. Someone had signed them for him or had directed him to sign documents whose purpose was obscured. I did not know which. I was not certain it mattered to the GBI. Finally, Patricia said, a letter from 11 affected clients who have been notified of potential trust account irregularities affecting their cases, all of whom have requested independent accounting reviews of their files. Carter, the bar investigator, had been writing steadily in a small notebook. He looked up. "Mr. Hartwell, I want to advise you that you have the right to have your own counsel present before responding to any of this." My father had not said a word. His attorney was not in the room because, as I learned later from Douglas, my father had been told this was a routine firm governance meeting. "Where is this coming from?" my father said. It was not a question the way it should have been. Douglas, who had said nothing until this moment, spoke. "Richard." He used my father's first name with the particular weight of someone who has been deciding something for several minutes. "We need to take a recess so you can call your attorney, and then we need to understand the scope of what we're looking at in terms of the firm's exposure." My father looked at me. "You did this," he said. I met his eyes. "You told me to find out what I was worth without your name." "I did." Douglas called the recess. In the hallway, he stopped beside me for a moment. "Evelyn knew," he said, then seemed to realize he had used the wrong name. "I'm sorry. I've been thinking of you as the person your grandmother described in the letter she sent me 4 years ago. She said you were the most precise legal mind in that building, and that her son would never acknowledge it." I did not know my grandmother had written to Douglas. "She sent letters to 6 of us," he said. "People who knew Richard from the early years. She said, and I'm paraphrasing, that if the day ever came when you needed allies in that building, she wanted them to already be there." He walked back into the conference room. I stood in the hallway for a moment, my hand against the wall, thinking about a woman who had sat in the front pew at my law school graduation and pressed a silver pen into my hand afterward and said, "This belonged to my first attorney." She was a woman who was told she was too precise, too detail-oriented, to everything they didn't want her to be. Keep it. I had used that pen to sign my bar admission certificate. I had kept it in my desk for 8 years. The morning I left, I had put it in my bag. The consequences were methodical and fast, the way institutional consequences are, when the documentation leaves no alternative. My father's license was suspended pending full investigation within 10 days of Patricia's complaint. The firm's trust accounts were placed under independent oversight. The GBI's inquiry expanded to include tax implications of the LLC's undisclosed income. My brother returned from wherever he had gone and retained an attorney who spent the first 2 weeks trying to establish that he had been deceived about the nature of the entity bearing his name. The bar investigator's notes, which I later saw as part of discovery preparation, described that position as not entirely implausible but factually incomplete. 11 clients received full restitution from the firm's malpractice insurance carrier, which had been notified by Douglas as a condition of maintaining the firm's coverage during the investigation period. 3 of those clients later called Patricia directly to ask if I was available to take over management of their cases. My father, through his attorney, made no attempt to contact me for the first 3 weeks. Then he left a voicemail on a Sunday evening. He did not apologize. He said that he understood I had made decisions I felt were necessary, and that he hoped in time the family could move past this. I listened to the voicemail once. I did not save it. My mother called the following Tuesday. I answered. She was quiet for a long moment before she said, "I watched him do it for 8 years and I never said a word. I was afraid of what speaking up would cost me." I did not tell her it was fine because it was not. I told her I understood the fear. I told her that the cost of speaking is not nothing, and I had never expected her to pay it. She said, "Your grandmother knew you would be the one." I said I knew. Douglas called the week after that. The managing partners had retained interim leadership while the firm stabilized. He said the firm wanted to offer me a named position, a full partnership, half the equity stake my father had held. I told him I was grateful for the offer, and that I was not going to accept it. He was quiet for a moment. "What will you do?" I had already signed a lease for office space on the 9th floor of a building 4 blocks away. I had accepted a retainer from 2 clients who had come through my grandmother's network. The managing partner in Buckhead, the one who had called Thursday morning, had offered a referral arrangement that would send me 2 high-asset cases per quarter, with full origination credit in my name. I told Douglas I was opening my own practice, specialty in high-asset divorce and fiduciary misconduct in family business disputes. He laughed, a short surprised sound. "Of course you are. My first office was 2 rooms and a shared reception desk, nothing like the corner suite I had occupied for 8 years without a nameplate. But the nameplate outside my door had my name on it, and I had ordered it myself, and nobody had suggested I didn't need one. I hired Jessica, the second-year associate who had left the sticky note on my computer. I told her she would receive origination credit for every case she brought in independently. She cried briefly and then apologized for crying, and I told her to stop apologizing and start billing. 6 weeks after leaving that dinner table, I sat in my new office at 7 a.m., with my grandmother's pen and a yellow legal pad and mapped out the first year's projected caseload. The firm was profitable on paper before the doors officially opened. My grandmother's last letter, the one I had not known existed until her attorney forwarded it after the bar complaint became public, was shorter than the one she had written years before. It was dated 3 months before she died. Claire, I don't know exactly when you'll read this, but I know it will be after the thing that needed to happen has happened. I want you to understand something I couldn't tell you while you were still inside that building. I structured every professional relationship I had in this city around you, not around your father, not around your brother. They had everything handed to them. You needed the door left open, not opened. There's a difference, and you always understood it, even when you pretended not to. Your father believed power was the name on the door. He was wrong. Power is knowing which doors open before you knock. I made sure you had that. I'm proud of the attorney you became without any help from anyone. Now go build something that lasts. I keep that letter in a frame on the wall above my desk. Clients ask about it sometimes. I tell them it's a reminder that documentation matters. That the work you do in the years before anyone is watching is the work that holds up in every room that counts. That the women who came before us, the ones whose names did not make it onto the wall, often left us more than we realized. I tell them that precision is not a supporting skill. It is the skill. Everything else is performance. My brother sends occasional texts from wherever he is now, brief and vague in the way messages are when someone wants to maintain a connection without discussing the reason it was severed. I respond when I have time. I do not have time often. My father's license remains suspended. His attorney has filed for a hearing. The outcome is not certain, but the documentation is complete. And documentation, as my grandmother understood before any of us, is the only thing that holds. I did not set out to dismantle what he built. I set out to find out what I was worth without his name. He asked me to do that on a Tuesday evening, in front of 40 people who went quiet when I stood up. 1 week later, he had his answer. So did I. If this story reached something in you, something about years of work that went unacknowledged, about the moment you finally stopped asking for permission to take up space, share it with someone who needs to hear that the careful, quiet work is never wasted. Subscribe if you want to hear more stories like this one, and leave a comment below. I read every single one.